Everybody has at least one question. Now, so you've decided for yourselves whether you're going to be Republicans, Democrats, supporting, opposing. If you haven't, decide that before you ask your question. Right? And of course, you can ask follow-up questions. And you can also just give speeches. That's what the senators do during these things. But you need to get the floor from the chair, and you will, when someone gets the floor, they'll have like 2 or 3 minutes, and I'll try not to use up their time, but you can then just decide when to cut them off. Okay. Action.
You can introduce yourself.
Well, would you?
Thank you, Madam Chairwoman. Let me just say what an honor it is to have been nominated by the President for this position. I have great respect for the court as an institution. As you know, many years ago, I had the good fortune to be a law clerk for Justice William Brennan. I also have great respect for all of the justices. Some of them are my former colleagues. I served briefly on the DC Circuit with Chief Justice Roberts, and I know him before that because, of course, we were both clerks for Judge Henry Friendly, and I think we have a lot in common in terms of what we learned from Judge Friendly. If confirmed, I will do my level best to apply the law fairly and even-handedly. I think I won't say anything beyond that, except to try as best I can within the bounds of judicial propriety to answer your questions. Thank you, Madam Chairwoman.
Oh, sure. In recent years, the Supreme Court has taken upon itself to revisit a number of its precedents, including making big decisions even on recent precedents involving campaign finance reform. What, in your mind, is the role of stare decisis in how a Supreme Court justice should approach disputes brought before the court? Does it depend on how recent the decision is, how old the decision is? What factors will you consider in determining how much weight to defer to previous courts?
Well, Senator, the Supreme Court has articulated a presumption, a pretty strong presumption in favor of adhering to its own precedents. And as you know, that presumption is justified on several grounds. First is the principle that no legal system could function if in each case all questions of law had to be considered as res nova, that is to say, as cases of first impression. And so simply as a matter of practicality, we need a presumption in favor of adhering to precedent. The second and probably the most important societal value served by stare decisis is stability to protect reliance interests. And so it's not surprising that the court, when it has articulated those reasons that justify a departure from stare decisis, has pointed to 2 main factors. First is the question, I refer of course to Payne against Tennessee as the leading modern case that articulates this. First is the question of whether the original decision was either unsound in principle or unworkable in practice, or potentially both. And if so, that argues in favor of overruling. And second is the question of whether there have nonetheless been substantial reliance interests, and to the extent that there are reliance interests, that counsels against overruling a case. I should say that I've stated the basic outlines of the stare decisis doctrine. Let me add that I agree with those basic outlines because it seems to me that they are founded on sound principles, and I would, if confirmed, strive to adhere to that line set by the court in the Payne case, and in prior cases, of course. Perhaps in the opposite of irony, Payne itself, while articulating the grounds for overruling cases, follows the cases that had been previously decided.
So how would you view stare decisis, in particular in the realm of campaign finance, where there's been a number of, where you had McConnell, then you had Citizens United, and now there's been a number of other cases that look like they are loosening up restrictions. I am well aware that you can't tell me how you're going to rule in any particular case, but in the area of campaign finance, where the law seemingly changes frequently, how strong would you say the presumption of stare decisis would be here as a judge?
Well, Senator, let me try to answer that question in two ways. First, as you noted, I don't want to, nor could I in good conscience, pre-commit myself to any course of action with respect to campaign finance or any other topic. And so I don't want to say how I would resolve that issue because, of course, I would have to consider the briefs and the arguments and so forth. I would, I think, quibble a little bit with the premise of your question, which is that this is an area of law in which there has been just a constant back and forth. It's true that McConnell upheld BICRA on its face, and then Citizens United invalidated it as applied. And one would have to make one's own judgment as to whether those two are consistent. It's also true that McConnell pretty much expressly overrules Austin against Michigan, the Chamber of Commerce. And so viewed at that level of detail, I think it's fair to say that those cases do reflect a kind of volatility. But viewed in broader perspective, I'm not so sure I would say that. After all, remember that Buckley against Vallejo was decided in 1976. Now that's 40 years ago. And there has been a great deal of criticism, including from justices who still sit on the Supreme Court, of the Buckley framework. And yet Buckley itself hasn't been overruled. And so I think that any decision about whether to treat this as an area in which there's less weight to stare decisis because there has been some churning with respect to details would also have to take account of the stability of the basic framework established by Buckley.
So if I'm understanding you correctly then, the framework behind Buckley, that's entitled to greater stare decisis deference than perhaps the details at play in the Michigan case and Citizens United, McConnell, and McCutcheon. Those details that are filling in the interstitial gaps in the framework set up by Buckley?
No, Senator, perhaps I was inarticulate. You had suggested that, in your initial question, that perhaps there would be less weight to stare decisis in light of the volatility of recent cases, without committing myself to the proposition that one can adhere to the core while tinkering with the periphery. I would just note here that the core is relatively stable. And I would also point out that this is a proposition that the Supreme Court itself has accepted. So, for example, in another one of the leading modern era disquisitions on stare decisis, the court in Planned Parenthood against Casey tells us that it's going to affirm the values of stare decisis by reaffirming the so-called central holding of Roe v. Wade, even as it tinkers on the edge with some of the details. And so all I'm saying in drawing that distinction is that in considering whether to overturn any particular campaign finance decision in any direction, I would want to be open to the possibility that there might be reasons for less weight to a peripheral decision than to a central decision without committing myself to that distinction.
So I'm Senator Marco Rubio. I have a question.
Yes, I know who you are, Senator. It's very nice to
I like
to
your
see you again.
tie.
And I really appreciate the very nice meeting we had in your chambers.
Yeah, I thought we had eggs and oatmeal or something. I'm not sure. So my question, it's alleged, other than by the NRA, that you want to take our guns away. It's alleged that you're a relatively moderate candidate for the nomination, or for the confirmation. And my question is, since you would be ascending to a relatively divided court, whether your role as a moderate, you find that you have a different responsibility being the only moderate in the room to broker some sort of agreement, or whether you just decide the case as you see the case from your own perspective. I guess my question is whether you take the fact that you are one of the more moderates in the room, and your vote will likely decide a lot of these hot-button cases, whether that factors into your decision-making.
That's a very interesting suggestion, Senator. I thank you for it. Let me just say that I tend not to think in those categories. If politicians or pundits want to characterize my record as moderate or liberal or conservative, they're going to do that. I think of my job as following and applying the law, and that takes me where it leads me. As you know, in the U.S. Court of Appeals for the D.C. Circuit, we sit in panels of 3. Sometimes I find myself in the middle between my 2 colleagues. Sometimes I find myself on one side or the other. I do think, if you look at my record, that you'll find that I always have strived to build consensus. In the time that I've been on that court, which is now over 20 years, I've only dissented on 14 occasions, which I don't know the exact statistics for the judiciary as a whole, but I would be surprised if that's not lower than average. And so I don't look for opportunities in my current role to depart from the consensus of my colleagues. And although the role of Supreme Court Justice is in some ways a little bit different from that of an appeals court judge, I think in this respect, it reinforces the tendency towards moderation because one needs to find common ground among 5 out of 9 as opposed to 2 out of 3. And that's just a more complicated equation. So the short answer to your question is, insofar as one could characterize my record heretofore as moderate, I see no reason to think that wouldn't continue to be the case were I to have the honor to ascend to the Supreme Court.
Yeah, I think good.
So while you are pretty moderate in the criminal justice decisions, you tend to be more conservative. Do you think that's because you're a former prosecutor and you see that side?
Well, again, I would resist the characterization of moderate, conservative, liberal. It is true, I think, that each of us is a product of our experiences, as you allude to. I did have the honor of serving twice in the Department of Justice, and that I played a role, others will have to judge how important a role, in the prosecution of some high-profile cases, including Mayor of the District of Columbia, Marion Barry, including the Oklahoma City bombing case. Nobody who has played the role of prosecutor can be insensitive to the cost of crime on its victims. The Oklahoma City case is a tragic example of that on a large scale, but one encounters that on a smaller scale in just about any criminal prosecution. At the same time, I should say that the experience of working as a prosecutor makes one especially sensitive to the importance of following the rules and upholding the rule of law. If you look at the history of the Supreme Court, I think you will find that former prosecutors have been prominent in insisting on lawful behavior by the police. So just to name 3 examples, Justice Robert Jackson was Attorney General of the United States. most famous perhaps for supporting civil liberties in the Barnett case and in his dissent in the Korematsu case. Chief Justice Earl Warren was Attorney General of California before becoming Governor of California, before ascending to the Supreme Court. And we think of him, I think rightly, as in some sense the father of the modern limits on police and prosecutors. On the current court, Justice Sotomayor was a prosecutor before becoming a district judge and then an appeals court judge, and she has been quite sensitive, I think, to the rights of the defendants. At the same time, so was Justice Alito. I think that it's fair to say that there are some differences between the two of them. But I would say that I see myself in the broad tradition that includes all four of those people, which says that as a former prosecutor, you care a great deal about justice for victims, but also for fairness to defendants.
To sort of piggyback off that question, United States versus Texas recently brought up the issue, sort of the general idea of the executive's ability to refuse to enforce or to not enforce duly enacted laws. What is your position on whether, and if so, to what extent, the executive can not enforce laws that are on the books?
Well, Senator, my perspective probably is informed by the fact that I sit on a court with a heavy administrative law docket. And so when I think about the question of non-enforcement, I tend first to think in terms of the Administrative Procedure Act. The Administrative Procedure Act makes non-enforcement decisions under certain circumstances reviewable by the courts. Right, so the leading case here, of course, is Heckler against Cheney. And Heckler against Cheney provides that the simple exercise of prosecutorial discretion is generally not reviewable, but that there are limits to the ability of the executive simply to choose not to enforce the law. There's a further question, of course, about justiciability, and my colleague Judge Kavanaugh wrote an opinion a number of years ago in an important case in which he took the position that a decision not to enforce on the part of the president the exercise of prosecutorial discretion, this was in his opinion speaking only for himself, Judge Kavanaugh, who, as you recall, was appointed by President George W. Bush, Judge Kavanaugh took the position that such a decision is not reviewable because, among other things, the president has the pardon power, and so if the president can pardon somebody for committing a crime, a fortiori, the president can decide not to prosecute. I'm not sure I would necessarily agree with that inference. It seems to me that a lot of enforcement decisions will fall outside of the realm of prosecutorial discretion as influenced by the pardon power simply because they arise in the civil context. And so, for example, the case you give is a case where the executive action or non-action, if you will, is deportation, and that's not going to give rise to a possibility of a pardon. But I think that the question of the president's enforcement or non-enforcement power is really not one question, but it's a whole set of questions. It's a question about justiciability in the first instance. It's a question about the differences between criminal and civil enforcement. It's a question about judicial review of agency action, which presumably Congress itself could alter by making amendments to the Administrative Procedure Act or making certain agency action or inaction subject to it. So without prejudging the outcome of any particular case, I guess I want to say that thinking about that issue as a question of what are the limits on the president's power to not enforce the law, when does that bump up against the take care clause, is, to my mind, too general a way of thinking about it. I would have to know about the particular context in which it arose, and then I would want to think about first whether this is an appropriate question for the courts to resolve, and then secondarily, what the right way to resolve it is. So let me stop there. I have more thoughts on that, but I think that's how I would think about that kind of a question.
Combining those two previous questions together a bit, last term in a dissent, Justice Breyer and I believe Justice Ginsburg discussed the arbitrary way in which prosecutors pursue the death penalty and question the constitutionality of the death penalty as a result. As a prosecutor who oversaw a prosecution that ultimately sought and secured a death sentence, what factors did you consider when exercising that discretion, and do you think that those factors can be consistently applied such that it justifies the continuing vitality of the death penalty?
So without answering the ultimate question, let me say that when I was in the Justice Department, and I assume you're referring to the McVeigh case, the discussions about what to do in the McVeigh case included me, but the ultimate decision, of course, was above my pay grade. That decision was made by Attorney General Reno and President Clinton. Of course, I had some input into that. I can tell you what the Justice Department policy is, and that is, as it has been under every president since we've had a federal death penalty, that the death penalty is reserved for the most serious cases in which, applying the Supreme Court's precedents, the aggravating factors outweigh the mitigating factors. Now, whatever one's view about the ultimate desirability on policy grounds or even constitutionality of the death penalty, it does seem to me that we made the right decision that if you are going to have a death penalty and you are going to use it at all, that applying it to the worst perpetrator of an act of domestic terrorism at the time is an appropriate use of the death penalty. I do take it, however, that your question is, do I think, as the justice for whom I clerked, Justice Brennan, thought, that the death penalty is cruel and unusual under all circumstances, and as he continued to say throughout his career, the answer is I haven't had occasion to think about that question in a context that would allow me to really draw a firm conclusion, because, for one thing, we don't get capital cases on the DC circuit, and even if we were to, that would not be within my power. The Supreme Court case law currently allows for the death penalty. I read Justice Breyer in his separate opinion there to be inviting a challenge to the death penalty, and I think if that challenge were to arise and I were to be on the court at the time, I would consider the arguments for and against, taking account of what has changed since the court so-called reinstated the death penalty in Gregg against Georgia and its companion cases, but also taking account of stare decisis.
Before moving on, are there any other death penalty or habeas related questions? Zach, did you have a question? Or did Zach? Yeah. Zach, please.
We'll ask. Do you believe the Constitution is a living document? If not, why not? If you do, how should judges determine your rights?
Well, Senator, that's a profound and somewhat abstract question, and if I may, I'd like to answer it by once again suggesting that it rests on a potentially false picture of what it is that justices do. So I take it that the notion of the Constitution as a living document which is a metaphor that first arises in the 19th century, is typically contrasted with what is sometimes called originalism, the notion that the meaning and in some versions the application of the Constitution is fixed at the time that the Constitution is adopted. I'm not sure I have a judicial philosophy per se that sharply distinguishes between those two schools of thought. That is to say, I agree with my so-called originalist and textualist colleagues who say that whenever one has a constitutional case, one necessarily starts with the text, and one has to understand the text in the context in which it was written. But of course, society changes, and so that's why it seems to me that many people today in academia and on the bench who call themselves originalists recognize a large area in which judicial decision, even that is faithful to the original understanding of the Constitution, will evolve with changing circumstances. That was true even at the time that Judge Bork wrote about that in his opinion in Evans against Ullman in the 1980s, right? That the task is to apply the words the framers wrote in their time while preserving the meaning to the different world in which we live. I'm paraphrasing, but that's the basic idea. And so I think that that sense of a living Constitution is inevitable. Society changes, circumstances change, new laws are passed, new circumstances arise. As thermal imaging a search within the meaning of the Fourth Amendment. Whether one calls oneself an originalist in the broad sense or a living constitutionalist in some sense, what one is going to do to answer that sort of question is to look to the kinds of cases we've decided in the past, look to the examples that the framers had in mind, and try to apply them in a sensitive way to this new context. So I don't want to declare myself an adherent to the living Constitution, or as the late Justice Scalia jokingly sometimes said, to the dead Constitution. I think that what we have is the Constitution, and I'll do my darndest to get it right.
Given that you have just mentioned the late Justice Scalia, I was hoping to get your opinion on one of his opinions. And perhaps you could give us your understanding of the limitations of that opinion. Of course, without sort of answering potential questions that may come up before the court, at least one that we can foresee. So could you talk about your view on Scalia's opinion in DC versus Heller, its limitations, and perhaps whether or not you think it was wrong directly?
So first I should say that, as I'm sure this body is aware, when I was a judge on the DC Circuit, I voted to rehear en banc the case that eventually became District of Columbia against Heller in the Supreme Court. I did so because I thought the case presented an important question and that the ruling was arguably inconsistent with U.S. Supreme Court precedent, or at least that was a possibility. And so I thought that under our rules that warranted rehearing en banc. That was a judgment not about whether the Supreme Court was right or wrong in Heller, but about the state of the law on the Second Amendment prior to the decision in Heller. With respect to the limitations of the opinion, I think those are relatively clear from the opinion itself. The Supreme Court announces two kinds of limitations on the individual right to own and possess firearms. First, that it only applies to firearms or weapons that are in common use for individual defense. And I think that the lower courts have had a relatively easy time, therefore, saying it doesn't apply to such to exotic weaponry. There are hard line drawing cases that the Supreme Court's recent per curiam in the knife case shows, but that's one kind of limitation. And then there are, I would say, again, just going based on the opinion in Heller and in McDonald, there are particular categories of exemptions. So sensitive places, such as courthouses, the Senate, airports, and so forth, where the people can be asked to proceed without weaponry. That particular categories of persons can be denied weapons otherwise suitable for self-defense, people who have been convicted of felonies, people subject to protection orders, people who have been adjudged mentally ill and dangerous. These are all limits in the court's opinion itself. Now, if the question is whether I think that the basic determination that the Second Amendment protects an individual right as opposed to a so-called collective right or right of the states, I should say that if such an argument were made, I would have to consider it in light of the same stare decisis framework that we apply in other contexts. I would note that the Supreme Court has just this term applied Heller in this question of what kinds of weapons count as in common use. And so there doesn't seem to be momentum for questioning its premises, and I would not come to the court with any agenda. I would just, call them as I see them.
First of all, congratulations to you and your family. This must be a momentous day for you.
You have no idea, Senator.
As a senator from Vermont, I've obviously been running for president for the past year, and a big part of my campaign has been that I am not using a super PAC. I've collected over $70 million.
All right,
over
wait. You could just.
$27 a person. And I have stated publicly that I believe we have a corrupt campaign finance system. Now, let me just say this. I've read the opinion that you've joined in Speech Now versus Federal Election Commission. And it worries me because that opinion allowed unlimited contributions to the super PACs. I've also said that if I were elected president, that I would have a litmus test that would say that the judge would have to, if given the opportunity, overrule this horrible Citizens United case. And so I would like to ask you, if given the opportunity, would you overrule the Citizens United case?
Senator, with due respect to both the substance and fervor of your views, I'm afraid I can't answer that question because to do so would be inconsistent with the appropriate role of a judge or a justice, which is when a case is presented either as a case of first impression or where the issue is whether to overrule an individual case or a whole line of cases, I would have to listen to the arguments with an open mind. And certainly, I will listen to the arguments of the sort that you just made. That's all I can say in good conscience. I will also say that I spent many an enjoyable vacation in the great state of Vermont.
I have a follow-up to your answer, which is Justice Ginsburg had in kind of press and in publicity been quite forthcoming about cases she has found to be wrongly decided or kind of incongruous with current policy. And I wonder what you think. I'm thinking particularly about Geduldig and the aftermath of Roe v. Wade, if it should have been better reserved for states. And I wonder what you think the appropriate kind of public face or public statements of a judge in the Supreme Court should be.
The court in which I now sit is governed by the ABA rules of judicial conduct. The U.S. Supreme Court is not. And so each of the justices must make up his or her own mind about what kinds of public engagement are consistent with the judicial role. Let me just say that my own style has been not to have much of a public presence beyond my opinions. I recognize that that's not universal even for an appeals court judge. Part of it perhaps is that I don't know how someone like Judge Posner finds the time to be a full-time appeals court judge, to write 2 or 3 books a year, and to give lectures. I can't do my job that way. Other judges on the courts of appeals have occasionally stepped into the limelight. The reference you made to Justice Ginsburg, I believe, refers to a speech she gave. It was the Madison Lecture at NYU, which was published after she became a Supreme Court justice, but was given when she was still a member of the court in which I now sit. And so there are judges and Supreme Court justices who take the view that it's perfectly appropriate for them to comment on matters of public concern, and it doesn't seem to correlate with ideology or anything else. I would just say that that's not my current plan. I don't want to pass judgment on however anybody else decides that. I do think that I have no current plans to change that attitude. I certainly don't imagine that I possibly could, at least in my first 5 or 6 years on the court, given how much I would have to learn just to get up to speed on the job. I would think I would have my nose to the grindstone and not sufficient time to engage as a kind of public intellectual, which again, I want to be clear, I think has value, and other members of the Article III judiciary can draw their conclusions.
The Supreme Court here gets requests to hear cases, petitions for writs of certiorari, thousands a year, but the Supreme Court typically only hears about 80 cases a year. Do you think the court should be more active and hear more cases, fewer cases, and I'm asking you a lot at once, but I also know that the number of cases the court has taken from state Supreme Courts has gone down. So in terms of the types of cases the court hears, where do you stand?
So again, if I were to be confirmed, I think as the rookie on the court, I would not be in the best position to make a judgment that my colleagues aren't working hard enough. I imagine I would have to be working very hard. I will say that it's quite possible that the decline in the number of cases from the state courts is a reflection of the fact that with the exception of Justice Kagan, every current member of the court was a federal appeals court judge, at least briefly, or in some cases for a longer time, before coming to the Supreme Court. And of course, Justice Kagan, while not a federal appeals court judge, also wasn't a state court judge. So it may be that by selecting, and of course I would do nothing to change that, but that by selecting judges for the Supreme Court who are currently judges of the federal appeals court, there's a kind of built-in bias towards seeing cases in the federal appeals courts as more important than cases from the state courts. I doubt that any of the current justices would articulate that as a policy. I know that there has been some speculation as to why the court's docket shrank dramatically since the mid-1980s, when it peaked at about 200 cases a year to its current numbers. Part of it is undoubtedly the changes that Congress made in the court's mandatory appellate jurisdiction in 1988, but there's also a decline that occurs in the late 90s that's not a consequence of any change in the jurisdictional statute. I'd like to think that the reason that the Supreme Court is taking fewer cases is that we lower court judges are just getting it right a lot.
In 2003, you joined a panel opinion that decided that federal district courts lack habeas jurisdiction over detainees in Guantanamo Bay. Given that the Supreme Court subsequently reversed that in a 6-3 decision, do you stand by the initial decision in which you joined, or has Justice Stevens informed your opinion?
Well, no, of course I mean, I was overruled and the law changed. I will say that the view that I expressed at the time was based on, that I joined at the time, was based on what had been the conventional wisdom about what the Supreme Court meant in the Eisentrager case. That is to say that habeas doesn't run to enemy aliens without prior connections to the United States held outside the United States. Now, part of the change in the operative framework was the, as Justice Stevens said in the initially in the Rasul case, and then in Hamdan, the court says that in Hamdan, was that Eisentrager was chiefly a statutory holding, and that Braden and Arons interact to change the statutory understanding, and we could have a long debate about whether that was the best reading of those cases and whether the statute changed or not, but I think that would be entirely moot at this point, given that that Congress changed the statute in both the Detainee Treatment Act of 2005 and the Military Commissions Act of 2006, so that whatever disagreement I might have had with Justice Stevens in the early 2000s over statutory interpretation is now superseded by the Supreme Court's determination in Boumediene that there's a constitutional floor for the writ, and it runs to a place like Guantanamo. So I have no interest in revisiting that debate. I'm happy to have been corrected. I get reversed from time to time, and I might want to fall back on the admission of the court that they're not infallible because they're final. They're not final because they're infallible. They're infallible because they're final. But I see no reason to relitigate that. I'm not sure if I've answered your question satisfactorily, Senator.
I wanted to ask a question about Indian law. I know you have a somewhat limited record on that topic area, but you have referred to the federal government's trust relationship with tribes before, and I was wondering what your current understanding is of the sovereignty of federally recognized tribes and what the nature of the trust relationship is between the government and tribes.
So first, I want to acknowledge that in describing that relationship as a trust relationship, I do not want to in any way suggest that the United States has, throughout its history, been a fair or certainly not generous trustee. That the treatment of Native peoples by our government has been shameful at times. It is also true, however, that over the long course of U.S. history, as bad as the relationship has been between the federal government and the tribes, it has often been worse between the state governments and the tribes. And that, therefore, when you look back to the great decisions of the Marshall Court, Worcester in Cherokee Nation, The characterization of tribes as dependent sovereign nations is a way of protecting tribes against the assertion of sovereignty, complete sovereignty, by people acting on behalf of the states. I think that going forward, that continues to be the case, and so that there is a uniquely federal role in protecting the sovereignty to the extent that we use the word sovereignty. I would say partial sovereignty, or we could say quasi-sovereignty. The words to me are less important than the status of the tribes. Now that is a duty that falls first and foremost on the political branches of the government, through treaties, through statutes, through preemption of state activity. But when those cases do reach the courts, I think that we do have a special duty to take account of the unique role of Native tribes in our constitutional system.
I do a quick follow-up to that. So you referenced the Marshall Code, but it seems like the court, in most of its recent decisions involving Indian law, have somewhat backtracked on what they've limited the scope consistently of what they consider tribes' sovereignty to mean.
Well,
what's your perspective on that?
So let me say, Senator, that to the extent that a lot of this depends on the particular statute. So if we think, and I think there are two characteristics of the court's modern case law. One, which I think is a work in progress, is the tendency to treat tribal status as a kind of racial status. And you see that in the Hawaii cases, you see it in some of the ICWA cases. I haven't thought enough about whether I think that's the appropriate analogy, but I should just say that it strikes me that there are both similarities and differences between tribal status and racial classifications. And I would want to the extent that there remains an open space in the law, I would want to consider the possibility that we shouldn't just adapt the cases involving racial classifications to cases involving tribal status. The second thing I would say is that in a lot of these cases, what you have is really just statutory interpretation, and that to the extent that you're asking whether the court has been insufficiently sensitive to the role of the tribes in interpreting the IGRA or ICWA or any of the other statutes, I understand the argument for that proposition. I would be open to hearing such arguments, and again, within the confines of our rules of stare decisis, to potentially going down a different path. So I'm aware of these arguments. I think there may well be something to them, but I don't want to prejudge them.
Would you like closing remarks
No.
at this point? Okay.
So it's been widely reported that you were a vegan, whatever that means. So I'm assuming you're anti-abortion. But if that's not right, can you explain your views on the current
Merrick
state?
Garland is a vegan?
I made that up. I'm just I'm getting to the question, that was a joke.
I'm staying in role.
Oh, that's fine. So what are your views on the current state of the law with respect to abortion?
So we will find out what the meaning of the undue burden test is in the current cases before the Supreme Court. I think that this is an area in which, again, like Buckley against Vallejo, where you have a lot of volatility around the edges. There are people who say that Gonzalez against Carhart, while nominally not overruling Stenberg against Carhart, really does overrule it. Right? Nonetheless, the core framework has been stable, depending on how you count, either since 1992 or since 1973. So if confirmed, I would come to the court with the strong presumption that this is an area of settled law. And it's not just that it's settled. The court in Casey, and I believe there were 5 votes for this portion of the opinion in Casey, the court treated the threshold for overruling Roe as not simply the ordinary Payne against Tennessee standard, but as requiring something even beyond that because of the large-scale institutional implications. And so whatever my views might be about whether Roe is rightly or wrongly decided as an initial matter, I think that anybody who would want to do away with the framework that's been in place more or less now for 44 years would have a heavy burden of persuasion, simply because of the way our system of precedent works. Well, Senators, I do very much thank you for holding this hearing, and especially Senator Sanders for your pressure to ensure that this hearing was held. I appreciate that very much. All right, and scene. Man, that was hard.